Sir Rick here, reminding you to tune in to our new segment called The Sledgehammer, featuring those who make a legal difference in our industry.
All right, and we're back here on BCB Live, the safest station in the nation. Drive Safe Dave here, along with Gerald Childress. Yes, he's an attorney at law at Childress Law Firm. We are excited to have you. How you doing today, sir?
I am excellent, Dave. Thanks a lot for having me.
Yeah, absolutely. So let's start off with the big question. Where are you at? What's the weather going on right now there?
I am in Indianapolis, Indiana. It is about 45 degrees, which is pretty warm considering we're almost into December, and it's a nice day today.
Well, you know what, Jerad? Just to break your heart a little bit, we're going to be at 70 today here in Dallas. So,
my goodness,
and the sun. So
good.
I know you're gonna feel sorry for us over here, right? In short sleeves, and getting putting suntan lotion on our face.
Can I get one thing out of the way too? I noticed when you were talking about your pies earlier, you did not mention the best Thanksgiving pie, which is pecan pie.
Yeah, no, I said I had, but we say.
No. Listen to how he said it.
Yeah, pecan. We call it pecan. And by the way, that's my state tree. So I think that's the Texas state tree. So I get to call it whatever we call it. It's pecan pie.
All right, I'll take that.
And my mom made it this year. Oh.
Okay.
Oh yeah, it was good. Oh yeah.
Pecan. What is wrong with him?
No, I'm good with it. You know what? If y'all get a piece of that up there, it's good stuff. Did you have a good Thanksgiving?
I had a great Thanksgiving. Spent a lot of time with family. Had some pecan pie and a lot of turkey. So still wearing the sweatpants right now.
Stretchies. I got stretchies on too. Look, let's jump right into it, Childress. Let's talk right into it, Jerad. Let's talk a little bit about what you do. First of all, who you're with. Let's go right. Tell us a little bit about yourself.
Sure, yeah. Jerad Childress. I'm a transportation attorney. I practice out of Childress Law with one other law partner. I'm also a vice president at Truck Safe Consulting. Both companies are focused on assisting motor carriers with DOT compliance, risk mitigation, and all of those projects that kind of fall under that category.
You know, I'll tell you what, real quick. You used to work at Scopoletis, correct?
Yep, Scopoletis Law Firm, indeed.
Yeah, which is probably one of the biggest transportation law firms in the country, right?
It is the largest transportation law firm in the country. Yep.
Look at you. What do you get when you work a place like that and then come out on your? What was the biggest takeaway?
Oh, there were many. I mean, it was a fantastic place to cut my teeth in the transportation industry. Some really, really fantastic experienced attorneys there from every facet of the transportation practice. So I was able to learn a lot of different areas and really just drink from a fire hose from the years that I was at Scopoletis. So very grateful to the folks there, and it was a great place to learn the transportation industry, without a doubt.
So you pretty much got Childress Law Firm. You've pretty much gone and doing a transportation business. Here's the big question. What is the biggest issue that you see right off the bat, Jerad, almost every single time?
Typically when I come in to look at a motor carrier's compliance operations, my approach is generally hours of service is your biggest problem, change my mind. And oftentimes, I'm proven correct that hours of service is often the biggest issue with a lot of carriers. And it becomes the biggest issue because it manifests at roadside heavily. It manifests as a big problem in highway accident litigation. And also in the event of an actual DOT audit, we know that hours of service is double weighted. So it's a very, very big issue, and it can actually be the single thing that sinks you with your safety rating in the context of a DOT audit. So hours of service specifically, there's a lot of layers of the onion to peel back with hours of service, but generally speaking, it's hours of service is a really big problem.
Yeah, Jerad, and I'm going to ask you kind of as I build this, why would hours of service be such a big issue when we all have electronic logs and it's done automatically? Right? I mean, it shouldn't be that hard, right? If we have electronic logs that record that stuff automatically and report it correctly. Why would we have such an issue with that? And I ask you that because I want to hear you say it.
Well, ELDs, they've been around now for about 5 years. Obviously, in 2017, we had that 2-year period where you could use the AOBRDs, but generally speaking, we've been dealing with ELDs since 2017. They did a lot of good things. They did arguably some bad things, but one thing that they did was make it easier to discover violations, make it easier for motor carriers to track violations. So a lot of times, those violations become more apparent, which can become more problematic when the DOT is actually looking at hours of service during an audit. Now, there's a number of trends that have developed over the years with ELDs, driver-facing trends at roadside, and then also trends that we see in the back office systems with motor carriers as well. And I can walk through some of those if you'd like me to.
Yeah, why don't you just give us a quick kind of a tour of why. I think the ELD, as it came into effect, I think it without question did one important thing more than any, level the playing field probably, and then secondly, I would say created much data, more data than we've ever had in our entire lives. So go ahead and build onto that and tell us what it is you see and what it is you sometimes see that tends to be a problem.
Absolutely, and I will say one quick piece here. If I mention anything like personal conveyance or common ELD pitfalls, and you want to dig into those issues a little bit more, we have a lot of free resources on Truck Safe Consulting's website. So that's trucksafeconsulting.com. We've got a lot of free articles, a lot of free videos that you can check out to really dig into these issues a little bit more if you want to. But talking about driver-facing issues, if we look at the FMCSA's data that they release on roadside enforcement issues, we see some common pitfalls that continue occurring. I'll kind of walk through some of those here, but not having an ELD when you should have an ELD is still a violation that we're seeing at roadside, which is a little surprising. There's very few situations where you are not subject to the ELD rule, right? Like short haul, or if you have a vehicle that's a model year 99 or older. So understanding if you are required to have an ELD, generally speaking, if you're operating a commercial motor vehicle in interstate commerce, then you should have an ELD. And if you don't have an ELD, I typically recommend to my clients having just a brief little cover letter that's aimed at enforcement and informing enforcement why you aren't subject to the ELD rule. Putting that in the in-cab of all of your vehicles, that way drivers aren't responsible for explaining the short haul exemption and why they're not subject to the ELD rule. So that's a simple step that you can take to create clarity with enforcement, because confusion typically leads to violations. So not having an ELD, that's a common one that drivers have been getting violations on. Failing to know how to transfer logs. So if your device can't transfer a log for some technical reason, enforcement typically resorts to looking at the ELD interface or looking at the actual screen of the ELD itself. So it's oftentimes not a violation if your device can't transfer a log, but if you don't know how to transfer a log, you're certainly going to be getting a violation for that. And then kind of hand in hand with that, drivers should have either electronic or paper forms of their ELD manual, their transfer instructions, and then also a supply of blank logs, at least 8 days of blank logs in their truck. We see violations for that as well. Failing to mount the ELD properly. So if you have an ELD, it shouldn't just be stuffed in your pocket, connected to the ECM, or thrown up on the dash, just sliding around. You should mount that ELD in a fixed position in your vehicle and make sure that it's visible from a normal driving position. Another thing that kind of goes hand in hand with that one as well, you need to be able to hand the ELD to enforcement. If enforcement can't look at the ELD, put their hands on it, that can be a violation that you receive. So if your device can't be dismounted from the dash, or if you have a short tether that can't reach to the window, you could get a violation for that. That's one that we see a lot of on the driver's side. And then lastly, unassigned drive time. Every time that you log into your ELD, you'll get a prompt if there's unassigned time on the device. Don't ignore this prompt. Either accept or reject the unassigned time, because enforcement can see that unassigned time, and you'll probably get a violation related to that unassigned time if you neither accept or reject. Threw a lot at you there, but those are the common driver issues that we're seeing related to ELD at this point.
You know, I'm glad you mentioned every single one of those, because as a truck driver, all of those are real in-world experiences. Knowing how to transfer the stuff to the law enforcement, it should be pretty easy. And you should never accept unassigned driving if it's not yours. I mean,
Exactly.
If it's not yours, don't accept it. I mean, that's your log. If it's not,
and the important thing is accepting or rejecting it then pushes the time one place or another. If you reject that time, then it goes into that back office function, where then it's the responsibility of the motor carrier
Correct.
to look at that unassigned time, assign it, annotate it, do something with it. So you're helping the motor carrier as the driver by accepting or rejecting that time, and you're helping yourself, frankly, as well.
Okay, so we got some of the pitfalls in there, and let's honestly, we did talk about some of the pitfalls as they do and as they apply. Let's talk about some of the good things that has come from the telematics. How about scoring and tracking? What do you think about those, Jerad?
Yeah, that's a really big one right now, and I deal with that one with a lot of my clients as well. Many of the ELD systems offer additional telematics offerings, some of which motor carriers aren't even aware of. So first of all, it's really important to understand what telematics your ELD system is gathering. And when we talk about telematics, all we're talking about there is the long distance transmission of computerized data. That's kind of the definition of telematics. So we're looking at cameras, vehicle diagnostics, ELDs. Those are the main ones, right? So driver scoring metrics are often gathered in the background of these ELD systems. So it's recording things like speeding, hard braking events, unsafe starting, you name it. There's a lot of them out there. But these events are recorded, and ultimately, a lot of times there's a score that's generated and populated for that driver specifically. So if you have a driver that has a horrific score and you're doing zero coaching, zero remediation for that driver, that's a big problem, obviously. And we're talking about the 500-pound gorilla in the room, which is highway accident litigation and nuclear verdicts, right? If this if this scoring metric is not examined and acted upon, it could hurt you more than it helps you. So I would encourage you to get a handle on what's being recorded in the background for your telematics offering, and then make sure that you're taking the appropriate action, because coaching recommendations are often also generated in these telematics systems. But again, as you point out, this is a major positive. If you are gathering sufficient data, if you're not gathering too much data, and you're able to act upon it with your safety group, I think that the telematics offerings can be great for providing coaching, incentivizing safe driver behaviors, and just using the data generally that's being gathered, because it can be an overall positive, as you point out.
You know, I think, and Jerry, tell me if I'm wrong, being from the experience, if somebody sees and views the carrier as a good citizen, doing those kinds of things, making sure that they're looking at that data and they are coaching and they are providing assistance and they show a drastic improvement across the board of their drivers in scoring over periods of time when they first come in to later, maybe that additional training, that says big things to a jury. That says big things to a peep, right? Doesn't it? I mean, honestly, if you're being a good citizen out there and doing the right things, that actually has a positive influence, right?
Absolutely, that's a great point, and a lot of what we've seen litigation turn into, particularly highway accident litigation, it's turning into this reptilian theory, where the narrative is much more about the reputation of the motor carrier as opposed to the actual actions of the motor carrier. Oftentimes, when the reptilian theory is employed, you'll sit through a deposition as a driver, and there's literally zero questions about the actual accident itself, the driver behavior on the day of the accident, the actions of the driver, whether appropriate or not. It's all about the motor carrier. What training did you receive when you came onto the motor carrier? How were you onboarded? What kind of coaching did you receive? And to your point, if you're appropriately coaching these drivers based on these triggered events from the telematics system, you take away that narrative, which is what I often tell my clients is one of the most important things, is controlling that narrative, because discovering violations, discovering issues related to industry best practices, you're allowing those things to be preached to a jury, and you are facilitating that bad narrative, that usage of that reptilian theory. So if you take that back, you take away that narrative, which is really, really critical, and your attorney can control that narrative and talk about the positive things that motor carrier is doing, and really make that narrative less about the reptilian theory and more about this is a motor carrier that cares about public safety, and much more than just moving freight down the road, which is what the plaintiff's bar would typically argue against a motor carrier in the context of a highway accident.
Yeah, I inside the courtroom, I think it's important to realize that if you can demonstrate your actions and prove that you're doing what you can, I think it plays into a big part, like you said, of them seeing who you are and what you're about. If you do nothing and you pretend, I think the days are over when I didn't know about it, so it's not my fault. I think, that if I just look a blind eye to it, then it's not really going to hurt me. I think those days are gone. Don't you agree, Jerad? You've got to dig in. You're responsible to find out everything you can to make yourself better and to be a better citizen out there on the road.
I agree with that. I think those days are definitely gone, but I'm still a little bit surprised by how many motor carriers that I do encounter that are unaware of what kind of things are being gathered by their telematics system. So again, I'd really encourage you to get into the back office of your ELD and take a look at any kind of coaching, scoring metrics that are being recorded, and understand that. And another thing, when we're talking about data generated from telematics systems, in the context of litigation, make sure that you understand retention periods on your videos. Make sure that you understand how you need to reach out to your telematics vendor and place a litigation hold on files, because I just encountered a case where a motor carrier had video that essentially exonerated the actions of the motor carrier, but for some reason the video footage, which was forward-facing video footage, was deleted from the camera system, and so that's just not there anymore. And at this point, that's now been turned against the motor carrier and is now being used to say, well, this video footage proved that the motor carrier's actions were inappropriate, and they're now subject to claims of spoliation of evidence, which is very bad. It means they destroyed the evidence on purpose. But in all actuality, it was evidence that really helped the motor carrier, but had they gone through the process of working with their vendor to secure that footage and make sure that it's retained in its native format, it would have been used in the lawsuit.
Well, and you obviously you work with many different carriers. What's a really big difference between working with the 20 or fewer with you and the larger trucking companies? Because you work with both. And I know that you each have their own dynamic. One probably has a larger safety department and not just one guy. What Jerad? What is it? How do you view both of those? And what are some challenges with both of those?
That's a great question, and it's a pretty long-winded answer that I'll try to give you in a short way. With the large carriers, you're right. They have a lot of resources. They have already developed and pretty mature practices in a lot of cases. And when recommendations are made, it's pretty easy for them to tackle recommendations. And so when I approach smaller motor carriers, I have to keep in mind that they don't have the resources that these larger motor carriers do. So I tailor my recommendations typically to make them digestible for the smaller fleets, because oftentimes the safety director may also be HR, may also be accounts payable, all these different things. So you got to understand who you're talking to and how many hats that individual is wearing, and tailor your recommendations accordingly. But oftentimes, like I said, the hours of service is just as big of a problem for the mega fleets as it is for the really small fleets. Now, it's much easier to put digestible policies in place with small fleets, just because you have less driver communication and education to do, and you're most times starting with a blank slate. And getting change affected in large motor carriers can be very challenging, particularly if the executive management team is not on board with updating policies and pushing things down the road. But just the kind of the red tape, the corporate red tape that you encounter with some of the larger motor carriers makes it a much bigger challenge than with the smaller fleets.
You know, Jared, we're sitting here talking, and I'm realizing something that as we continue to talk, being a law firm that comes in and gives advice, let's just say, you know, because I think an audit is important to a trucking company. It doesn't matter what size you are. I don't care if you're 1,000 trucks or you're one truck. I think an audit and an annual audit is something that you should do on a regular basis. Over there at Childress Law, y'all do that regularly, right? You provide and help provide audits. Because you're a law firm, are those audits considered attorney-client privilege and not subject to, you know, what do you call it when they
discovery?
Discovery.
Yes, indeed. That's one of the main things that we do a whole lot of. We're constantly juggling about 2 or 3 mock DOT audits, and the focus there obviously is preparing the motor carrier for an actual DOT compliance audit. And if a motor carrier has elevated scores or high accident rates, then we can advise them if they're at a higher or moderate risk of an actual DOT audit. But most of the time, motor carriers have a pretty good handle on, we're probably on a list somewhere. It's just a matter of time before we get this actual DOT compliance audit. So we're going to bring Childress Law or some other consultant in to do a mock audit. And yes, you're right. If you run a mock DOT audit through a law firm, it's going to be protected by attorney-client privilege. And so I would caution a lot of folks that are using consultants to understand that the findings of a DOT audit would likely be discoverable in the context of litigation if you do not run those through a law firm. So what you'd be doing in that instance is creating kind of a roadmap of non-compliance or compliance for a plaintiff's attorney. And if you don't take appropriate corrective actions on those violations that are discovered during that DOT audit, then you could just be setting yourself up for some heartache in the context of litigation.
You know, I'm glad, all this is digestible information. And before you get out of here, I just want to ask really quickly. We talked, you brought up, nuclear verdicts. I think it's important that I think everybody wants tort reform except plaintiff attorneys. But really, I think it's necessary for all of us in the business. I think it's all of us in this country to get it. I wonder with you, and me and you joked about it earlier, we've been talking about it for years with very little result, right?
Indeed, yeah. Tort reform's been discussed for 20 plus years. Realistic tort reform is going to be hard to come by, but if we look at places like the state of Texas, putting HB 19 in place, it's baby steps towards tort reform, and it puts in place real efforts to level the playing field, if you will. And the big things that HB 19 does, and I've talked to John Esparza, who's the president and CEO of the Texas Trucking Association, about this. He's actually come on our Truck Safe show as well and gave us a pretty substantive discussion about that. But making the video footage of crashes admissible in court seems like a no-brainer, right? But that's one of the things that HB 19 does, is make that video footage admissible in the context of highway accident litigation. And video footage is great for motor carriers because it either lets them know, hey, we as the motor carrier are at fault, we need to settle this case and get out of this and save a bunch of money in legal fees, or it says we need to dig our heels in and push this video footage over to plaintiff's counsel and say, we're going to be able to get this in because of HB 19, and this is going to hurt your case big time. Let's settle this case, get out of it. And it helps the motor carrier in that regard. Another thing that HB 19 does, and again, these are baby steps towards tort reform that other states should strongly consider, bifurcation of trial between liability and damages phases is something that can occur with HB 19. Obviously, plaintiffs' attorneys don't really want the bifurcation of trial because they want to commingle liability and damages issues and have the jury hearing these reptilian theories put forth in front of the same jury that's going to be deciding on damages in the same venue. So HB 19 takes baby steps towards tort reform, but they're big baby steps, in my opinion, the first ones that we've seen for a long time.
Yeah, and I think to be helpful across the country, I think it's important that you join or you get involved with your trucking association within your state, Also, on a national level, it's not that much. It's not, in fact, it benefits you greatly. Also, it increases your voice. So I think it's necessary that we're all in this industry together. We all have a voice, and it should be heard if we're going to make any changes. And the only way we're going to get it done is do it together, Jerad. I truly believe that there's no one person or one state that's going to be able to change it all. We've all got to find a way to dig our heels in, just like you're saying, and figure out how we can get some of these baby steps in place in order to help with the level playing field. I think it's important. Jerad, real quick before we go, if anybody wants to get a hold of you over there at Childress Law, what's the best way to reach out, to contact you, or to find you out there on the web? What is the best way?
Yeah, you can shoot me an email on my email address here below on the screen, or you can go to childresslawpllc.com, check out our website. We don't have a lot of content on the website by design. If you're looking for helpful content, you should go to trucksafeconsulting.com and check out our articles, videos, and some of our trainings as well. So that's how you get a hold of me.
All right, we do appreciate it, Gerald and Jerad. I appreciate you coming in, talking to us, man. I hope to ask you back again soon. But before you go, I ask all my guests to say one thing. I ask them to state their name, who they're with, and that you're watching BCB Live, the safest station in the nation. Can you do that for me?
I got you, Dave. Hi, I'm Jerad Childress at Childress Law and Truck Safe Consulting, and you're watching BCB Live, the safest station in the nation.
Hey, all right. I appreciate you, Jerad. Thanks a lot, man. We'll see you later, and have a good week.